It is a landmark judgment then by the Supreme Court today, one that has been very strongly worded, very strong observations by the court, which has talked about freedom of expression and how 66A was misused. As the court said, as you saw in the story there, that governments may come and go, but this is a law that India would have had to live with, irrespective of which government was in power. But ironically, today you had political parties, the BJP, the Congress, everybody was welcoming this judgment by the Supreme Court. And these are the very parties. It was the UPA that brought in this draconian law, and the BJP government that used to, the BJP as a party which used to criticize it, had in the Supreme Court been arguing about why it needs to be retained with certain safeguards, and therefore there is a hypocritical position that political parties across the board have adopted on this case. Sanjay Parekh is an advocate. He appeared in this case on behalf of the People's Union for Civil Liberties in the Supreme Court. Shekhar Gupta, an avid tweeter himself and social media enthusiast, here in the studio with us. Also Shivam Vij, well-known blogger and journalist who has also been writing extensively on this issue. Gaurav Bhatia of the Samajwadi Party joins us tonight. Interestingly, only last week the SP government in Uttar Pradesh came under fire for arresting a young schoolboy because of a Facebook post that he shared on Azam Khan. We also have senior lawyer Raju Ramachandran joining us tonight from here in Delhi. Shivam Vij, let me first get your reaction. Just give us a sense of how big a deal this is.
It's such a big deal that many of us were nervous this morning and last night. We didn't know the judgment could go either way. And if it did not go our way, it would be our last chance. We wouldn't have another chance at this. This is the biggest judgment for free speech in India since the 1960s. This was the 66A was the biggest assault on free speech in India in decades. And now this judgment has set a precedent that if the government again tries to bring in any law to curb free speech on the internet or otherwise, this judgment, this excellent judgment, is going to be a precedent which is going to hold us good for many years to come.
Sanjay Parekh, did you really expect that it would turn out this way, although you were fighting the good fight for so long?
The question is on the basis of the law which was laid down by the court in previous judgments. I felt that this 66A cannot be sustained. But beauty of the judgment is that it looks into the constitutional parameters, lays down very clearly the demarcation that this is the area where the law cannot touch the freedom of speech and expression. That's the beauty of the judgment. The second important thing is, it clarifies that there is no difference between what comes in newspapers. Merely because the media changes doesn't mean that the right will be, fundamental right will be taken.
Which is actually what the government had argued, that the internet is different.
That's what. So this is actually the important thing which has been pointed out in the judgment.
We also have with us from Mumbai tonight Abdul Dada, who is the uncle of this young girl called Shaheen. And if you remember, a few years ago, she was arrested by the police in Maharashtra for putting up a Facebook post that had criticized the fact that Mumbai had shut down, virtually shut down, because of Bal Thakre's funeral. And what a nightmare. Those girls in Palghar, she and a friend of hers, were both arrested by the police. And Abdulji, you must be such a relieved person today. And what a nightmare that you and your family went through as a result of 66A.
Yeah, definitely. I am very much relieved and having very good night. Yes. And actually my family, my brother's family, we were it was a very dark night for us on that particular day. Not only they were arrested, but my hospital was also totally vandalized, and it was great loss to me.
How has Shaheen reacted to this judgment today?
She is very pleased. She has conveyed her regards to all the medias who have supported her throughout.
But if you could just take us back to when the arrests actually took place, because that is really was the biggest criticism of 66A, sir, the way that the police came with impunity and arrested people citing 66A, and how draconian it was. As you said, it was such a nightmare for you that night.
Yeah. Actually, they came to our residence, my brother's residence, where we want to take the statement of Shaheen, and with some known person, they took her to police station. They didn't say that we are arresting and all that, and after reaching there, they detained us.
Let me get Shekhar Gupta.
And this was actually...
Shekhar Gupta, the political irony, of course, is that as we were saying, the UPA got this law in. Kapil Sibal was roundly slammed, for bringing this in. And then the BJP, which protested at the time, Mr. Modi even had, I remembered his Twitter DP had changed to black. And then this government went and argued that this law needs to be upheld. Isn't this political hypocrisy? In fact, it seems across the board, political parties would have wanted this law or this section to stay in some way or the other.
I think certainly BJP and the Congress both wanted it to stay. Look, governments are basically ruling parties or parties with the prospect of coming to power are always statist. They want as much power as possible in the hands of the government, and then they want to have the discretion of how much freedom they give you. And they say, don't worry, I'll give you full freedom. If you see dictatorial regimes around the world, if you see, remember Musharraf, he always said, press is freer in my country than ever before. That's because everybody knows the rules, right?
Yeah.
So it's a bit like that. Governments always pretend that they want you to have the freedom, but they want to be able to decide how much you will have. The fact is, media is media. I have sympathy with those who feel that media is misused, or they are abused for no reason, or or there is calumny, or they are defamed. I am also in sympathy with the idea that defamation law in India should be strengthened. It's too weak. In fact, I would like Supreme Court someday, or government, or a good parliament, to decriminalize libel in India. Make it purely civil, but make it much stronger and much faster.
Which is a
because
fair point.
people's reputations are also. But same libel laws that apply to people in print, on TV, should also apply to internet. So
they do.
I mean, they both do. But 66A was in addition to
I'm saying those are good enough or bad enough. You don't need special laws for internet, because once you if this principle was allowed to pass, it was a matter of time, inevitably, before someone would have experimented extending it to conventional media. Even if the central government had not, some state governments would have tried. So I think it's a good thing as far as freedom of expression is concerned. This judgment is as important for freedom of expression as the Keshwaranand Bharti judgment for the basic structure of our constitution. Because in India, media particularly, there is no special law guaranteeing our freedom of speech. It is Article 19 as interpreted post-emergency by the Supreme Court repeatedly, and as widely supported by the people of India. Our freedoms have risen as a result of the social contract that followed the emergency, when people said it was wrong to gag the media.
But Mr. Raja Ramachandran, one of the arguments that the government gave in favor of retaining 66A was, and that is something that is often used in this country in particular, is that hurting religious sentiments in particular comes under the category of what is grossly offensive, and therefore if somebody posts something, for example, the Additional Solicitor General talked about obscene pictures of gods and goddesses and religious texts, and how depicting goddesses in bikinis or showing gods in sexual relations would be something that would be deemed highly objectionable, and that would offend people in this country, and that is why that perhaps this act needed to be retained with certain safeguards. That was the argument that was given in court. Mr. Ramachandran, what do you think of the merits of the arguments that were given by the government?
Nidhi, the Supreme Court was very clear in negativing this argument, because when it's a question of freedom of speech under Article 19(1)(a), restrictions can only be imposed on the grounds specified under Article 19(2), and therefore it must have a bearing on public order. Public order, which means tranquility of society generally, not hurting someone's feelings. The Supreme Court has also explained that under our constitution, unlike the American constitution, mere public interest will not do. You have to come within the narrow grounds specified under Article 19(2). And this law did not meet the tests of Article 19(2). And therefore, this general feeling of hurt, offense, etc., the court felt was something completely vague. Completely vague?
Which it was, because you had people arrested for Facebook posts on the Prime Minister, or you had people arrested for example, we just heard what those girls wrote on Bal Thackeray's funeral. Gaurav Bhatia, interesting that this court order has come today, just days after your government has been on the back foot in Uttar Pradesh for the arrest of a young schoolboy because of a Facebook post on Azam Khan. How do you react to this verdict today, Mr. Bhatia?
Since you are referring to the incident first, I would answer that. I think when you use the terms like UP government came under fire and has been on the back foot, you are not factually correct, because I am representing the UP government in the Supreme Court, and we did point out to the Supreme Court that the post on the Facebook attributed to another leader of Samajwadi Party was inflammatory and derogatory. And we also pointed out to the Supreme Court that sections of IPC, namely 153A and 505, which are far more serious than 66A, have also been invoked. Now the matter is sub judice. I think only the Supreme Court can decide whether the action was fair and is covered under those sections or not. So I would not like to discuss that. I would like to today just discuss the judgment that has been delivered, and to that I would say that the Supreme Court has held that section 66A is violative of article 19(1)A because it does not meet the two tests. One is the public disorder test and the other is the test of clear and present danger. This section has been very loosely worded. There is a lot of vagueness in the terminology used, and I would say that legislation being a very serious business, every word that is chosen in an act should have a purpose and a specific meaning. Vague words cannot be used to show the intent of the legislature.
Then do you welcome the court's judgment or not?
We respect the judgment and we welcome it to the extent that it upholds the freedom of expression. That is a right guaranteed to every citizen. And I think every person would value that right which has been given to a citizen of India, subject to reasonable restrictions imposed under Article 19, subclause 2 as mentioned by Raju Ramachandranji.
So you're not exactly celebrating it either. There is a but there somewhere. There is a caveat there.
No, I think Nidhi, it's not a question of celebrating. When law is declared by the apex court of the country, you have to respect that and follow it because it is binding on every citizen. And it is not as if we are villains, politicians are villains who are exploiting every provision of the rule book. That, you know, if something goes against us, we feel sorry and we feel sad and otherwise we celebrate. Let us not paint the entire...
But Gaurav Bhatia arresting a class 11 student for a Facebook post, something he didn't even upload. I know the case is in court, that's a different matter. But the police going to arrest a young boy, a teenage boy, a minor, I think that was also under dispute. But you're right, that was under dispute. But a class 11 student,
yes,
a class 11 student, is that really necessary? That is where, you know, the high-handedness comes in. That is where you all misuse the law.
Factually, I think, see how this story became very sensational. The media started reporting that a juvenile person has been arrested for making a comment on Facebook. The authorities and I even immediately intervened and we found out the age of the person, because if he is a juvenile then there is a special procedure to deal with a juvenile, and then it was found out he is a 23-year-old person,
which makes it
and
okay,
we had
apparently
placed that fact before the Supreme Court.
So it makes it okay to pick him up for a Facebook post because he is 23. 1 second, Shivam, that's the point. That's how 66A got
to the wisdom of the Honorable Supreme Court to judge whether the content of that Facebook is inflammatory or not, whether it is covered under the definition of section 153A. And
no, we're not debating 153A. Let's not digress. You're trying to divert the issue. The issue is that your government used a law that today the Supreme Court has found to be draconian and unconstitutional. Do you regret having used the law?
We should not be vaguely arguing like this. This is just the vice for which section 66A has been declared ultra vires. Because
do you believe 66A was a bad provision in the law? Gaurav Bhatia, do you believe it was draconian? Do you believe it was a bad provision in law?
How they can arrest?
Yes, I believe that it was a poorly drafted, very vague provision which was prone to misuse and arbitrariness. I say that.
Okay, we've got... yeah, 1 second, Shivam. Yeah, then
I think we should stop using the word misuse in context of 66A. Supreme Court has not struck down this law because of misuse, but because of bad law. But per se, its wording is bad.
Because of vagueness. Because of vagueness.
We've got Nalin Kohli of the BJP
the
also
Supreme
joining
Court has
us.
said that it doesn't pass the two tests.
I think many of the questions.
Let me point out one thing. Invariably, in all these cases, what happens is 66A is something which is bailable in nature. You bring in other offences to keep the person under arrest, and later on you drop them. This is what has happened in all these cases which have. That's what he brings in 153A and other laws.
Exactly.
Yeah, this is what happens.
It's not like these problems are going to go away.
Tough laws. 505 is a very rough law. I faced the wrath of that law very unfairly. I have stood in the court. I have taken bail as the editor of a major paper with good lawyers to defend me. Cop has stood all day holding my arm until I get my bail of 20,000 rupees, of which 10,000 had to be paid in cash in 100 rupee notes. And Bombay court procedures are that the full number of every note had to be written by a clerk. So, you know, it was like a day's punishment there, right?
A nightmare.
Let me
it was another
addiction, but to have harassment.
Let me also point out an important thing in 66A. The element of defamation is not there. The judgment has ruled that. Element of defamation, morality, these two things have been ruled out.
But let me ask Nalin Kohli of the
any
BJP
insult
though.
to gods, I also agree that nobody has the right to offend anybody's gods or anybody's way of worship.
But there are laws that are dealing with that already.
There are laws, they are much tougher laws than this.
That already deal with
except maybe because those laws have been around a long time, it's not so easy to misuse them.
Okay, Nalin Kohli, how does the BJP today explain its turnaround on this issue? Today, I mean, the Congress, of course, after, like I said, bringing this law in has welcomed it, but the BJP, you had a chance to stand up in the Supreme Court and say that we don't agree with this draconian law, and yet it is the government that has argued in the Supreme Court repeatedly that 66A should have been retained. How do you explain this double standard?
Well, actually, I don't know whether I would agree with the use of words you've chosen, Nidhi, in terms of double standard and all. I'll just simply point out what the government said in its affidavit and what the government, the Additional Solicitor General, Mr. Tushar Mehta, said also orally. And then you judge us whether you call that double standards or not. First, the stand taken was we do not seek to put any kind of seek to curtail the freedom of expression and speech as enshrined in Article 19(1)(a) of the Constitution. Two, that we understand reasonable restrictions under 19(2) is exactly what it is. We are not seeking a widening of that scope. Number three, we do not seek to in any way curtail the freedom of the internet, cyberspace or social media. And four, if the Honorable Court feels that Section 66A does not fall within the confines of 19(2), it can be struck down too. We have not opposed that. So therefore, to call it a U-turn, I disagree. Number two, as far as we see it, we've consistently said, and the BJP as a party is one who understands and respects the value of the social media, freedom of speech, all of it, after emergency and all. So all of that, looking at it, the law officer always defends a law and is doing his duty to the court. This is a matter going on from 2012. It didn't start in the last 2 months or 3 months. The judgment is a welcome judgment. It's been appreciated. And what it reaffirms is exactly what we've been saying, and which I think everybody would would accept with happiness, that you should have freedom of speech. There are restrictions on it that are enshrined in the Constitution, Article 19(2). That is the limits to what it should be. And the last point which came out on this discussion, 66A has also been looked as the cause for the arrest. It may have been a section that's invoked, but it was completely bailable. The fact is that the IPC sections have been working in terms of elongating that legal process for those against whom false sections have been put at all.
Let me ask Mr. Parekh, because I'm not the lawyer. The government couldn't have gotten up in court and said scrap 66A? Or are they now hiding behind loopholes?
I want to come in on this.
Yeah, okay, Rajaramachandran, yes.
Yeah.
Do you believe, Mr. Ramachandran, that the BJP, the government could have taken a different position in court on this?
No, I don't agree, and that's where there's a lot of confusion in the media.
Yeah.
I've made my stand clear that this is an absolutely correct judgment, constitutionally correct. But at the same time, we must all understand the role of a government, any government in a constitutional litigation. There is a continuity in government, whether it's the UPA government or the NDA government. As long as a law exists on the statute book, it has to be tested, and for it to be tested, it has to be defended. Constitutional law is not made on compromises, that the petitioner says it's a bad law, government says yes, I agree it's a bad law, and the court strikes it down. This is not how constitutional law is made. and it would be no law if it was done on a compromise like this. And therefore, as long as the government didn't think it fit to repeal this law, the government was duty bound to defend this law, and this is what it did. And because the law has been tested adversarially, with rival points of view being tested, that is why we have got good law from the court.